Start the second part. Distinguish between word contract and wordable contract. Word contract क्या है? When a contract ceases to be enforceable at law, it becomes void contract. पहले से भी enforceable at law नहीं है तो वो void होगा. Voidable, a contract which is enforceable by law at the option of one party but not at the option of the other is known as voidable contract. मतलब एक पार्टी अवॉइड कर सकते हैं, वॉइड कर सकते हैं उसको, तो वो वॉइडेबल हो सकता है. स्टेटस वॉइड कॉन्ट्रैक्ट कैन नॉट क्रिएट एनी लीगल राइट्स, इट इज अ टोटल नलिटी. वॉइड टोटल नलिटी है, पहले से ही बाय एनफोर्सेबल एट लॉ नहीं है तो वो कैसे करेगा कुछ भी. फिर अवॉइडेबल कॉन्ट्रैक्ट टेक्स इट्स फुल एंड प्रॉपर लीगल इफेक्ट्स अनलेस इट इज disputed and set aside by the person entitled to do so. Then nature, a void contract is valid when a void contract is valid when it is made, but subsequently it becomes void due to the one reason or the other. A contract may be voidable since very beginning or may subsequently become voidable. Right. A void contract does not provide any legal right to the parties of the contract. A voidable contract gives right to the agreed party to rescind the contract and claim the damages, etc. in certain cases. Effect: when a contract is void because of illegality, its collateral ट्रांजेक्शन्स ऑल्सो बिकम वाइड. मतलब अगर इलीगलिटी के लिए कोई ट्रांजेक्शन वाइड हुआ तो उसके बाद जो जो भी ट्रांजेक्शन हुआ है वो सब वाइड हो जाएंगे. फिर अवॉइडेबल कॉन्ट्रैक्ट डज नॉट अफेक्ट द कोलेटरल ट्रांजेक्शन. मतलब उसके साथ अगल बगल वाले ट्रांजेक्शन को अवॉइडेबल कॉन्ट्रैक्ट कुछ अफेक्ट करता नहीं है. चलो एक बार फिर. वाइड एनफोर्सेबल एट लॉ, पहले से ही वॉइड हो जाता है. ceases to be enforceable at law, it becomes a void contract. A contract which is enforceable by law at the option of one party but not at the option of the other is known as a voidable contract. Takes full and proper legal effect unless it is disputed. A void contract cannot create any legal rights because it results in nullity. Void contract is valid when it is made. A contract may be voidable since very beginning or maybe subsequently become voidable. A void contract does not provide any legal right to the parties to a contract. A voidable contract gives right to the agreed party to rescind the contract and claim the damages, etc. in certain cases. When a contract is void, it becomes illegal. Because of illegality, its collateral transactions also becomes void. A voidable contract does not affect the collateral transaction. मतलब voidable transactions उसके आजू बाजू वाले ट्रांजेक्शन को कुछ अफेक्ट करता नहीं है. फिर distinguish between illegal agreement and void agreement. Illegal, an agreement which involves the transgression of some rule of basic policy and is criminal in nature or immoral. अगर अगर कुछ criminal और immoral है तो फिर वो illegal हो जाता है. Void agreement is one which is not enforceable by law. Such agreement does not give rise to any legal consequences and is void ab initio. पहले से ही वो void ab initio हो जाता है. फिर collateral transactions to an illegal transactions are not enforceable. Collateral transactions to void agreements are enforceable. फिर parties may be punished for making illegal. Being void does not make a contract punishable. मतलब पहले से ही कॉन्ट्रैक्ट अग्रीमेंट void है तो उसके कोई पनिशमेंट नहीं लगती. फिर डिस्टिंग्विश क्वांटम मेरिट एंड एंटीसिपेटरी ब्रीच. Quantum merit literally means as much earned, that is in proportion to the extent of work done. Sometimes contract cannot be completed. In that case, if one party has already executed some work, then he is entitled to get the proportional amount to the extent of work done. In case of breach of contract, agreed party can claim क्वांटम मेरिट प्लस द डैमेजेस. क्वांटम मेरिट इज अवेलेबल ओनली इफ द ओरिजिनल कॉन्ट्रैक्ट हैज बीन डिस्चार्ज. मतलब इतना अर्न किया है. मतलब अगर कोई बिल्डिंग है और बिल्डिंग के पाँच छह माले 10 माले का बिल्डिंग का कॉन्ट्रैक्ट हुआ था बट उसने 6 माले पे आके बंद कर दिया, तो जो 6 माले तक का भी जो कॉन्ट्रैक्ट हुआ है उसका जो 6 माले बनाया है उसने, तो उसके लिए उसको पैसे मिल जाने चाहिए. वो क्वांटम मेरिट है. फिर एंटिसिपेटरी ब्रीच. मेरा कॉन्ट्रैक्ट Anticipatory breach. When a party to executed contract declares his intention of not performing the contract, it is known as anticipatory breach. मतलब अगर कोई पार्टी ऐसा बोलती है कि मैं मेरा परफॉर्मेंस नहीं करूंगी तो वो anticipatory breach है. Following remedies are available to the aggrieved party in case of anticipatory breach of contract. The aggrieved party may decide to wait till the due date. It may rescind the contract immediately and claim damages. मतलब वो दो चीजें कर सकते हैं क्या, या तो immediately rescind कर दे या तो फिर ड्यू डेट तक वेट करें. ड्यू डेट तक का वेट करें. May decide not to immediately rescind the contract. He can treat the contract alive and wait for the due date of performance. Consequences of treating the contract alive are as follows. The promiser may promise when the time for his performance comes and the promisee will be bound to accept the performance. If a agreed party decides not to immediately rescind the contract and wait for the due date of performance, and meanwhile, if government imposes a ban, then contract becomes void and agreed party cannot claim them. It's distinguish between contract of indemnity and contract of guarantee. Contract of indemnity and contract of guarantee. A contract by which one party promises to save the other one from loss caused by him by the conduct of the promisor himself or the conduct of another person is called a contract of indemnity. It is a contingent contract. A contract of guarantee is a contract to perform the promise made और डिस्चार्ज लायबिलिटी इंकर्ड बाय थर्ड पर्सन इन केस ऑफ डिफॉल्ट। मतलब कॉन्ट्रैक्ट ऑफ गारंटी क्या है कि मैं इस बंदे के लिए गारंटी ले रहा हूँ कि अगर ये कुछ भी गफला करेगा तो मैं इसके बिहाफ पे पैसे भर दूंगा, तो वो कॉन्ट्रैक्ट ऑफ गारंटी है। देयर आर टू पार्टीज इन द कॉन्ट्रैक्ट, इंडेमनिफायर एंड इंडेमनिटी होल्डर। इसमें तीन हो गए, प्रिंसिपल होल्डर, प्रिंसिपल लेटर, श्योरिटी एंड क्रेडिटर। There is only one number of contract. There is only one contract. One contract. There are three contracts in contract of guarantee. Liability. The liability of indemnifier is per primary and independent. The liability of surety is collateral और secondary. Primary liability is that of principal debtor. मतलब अगर उसने पेमेंट नहीं किया तो मैं दूंगा, तो मेरी लायबिलिटी सेकंड हो गई। तो जो मैं श्योरिटी हूँ उसकी लायबिलिटी सेकंड हो गई, और जो प्रिंसिपल डेटर था वो ही उसकी प्राइमरी रिस्पॉन्सिबिलिटी रहेगी। फिर नेचर ऑफ लायबिलिटी, द प्रॉमिस ऑफ द इंडेमनिफायर इज टू सेव द पर्सन इंडेमनिफाइड फ्रॉम अ कंटीजेंट रिस्क। The surety undertakes to discharge the liability of the principal debtor, which is not contingent but is subsisting. Example: A and B go into a shop. A says to the shopkeeper, "Let B have the goods. I will see you paid." Or A and B go into a shop. A says to the shopkeeper, "Let B have the goods, and if he does not pay, I will." तो ये गारंटी वाला हो गया। और अगर उसने नहीं किया तो मैं कर दूंगा, तो वो अपना इंडेमनिफाई किया, लॉस हुआ तो फिर मैं कर दूंगा। टू सेव अदर फ्रॉम द लॉस, कंटीजेंट कॉन्ट्रैक्ट परफॉर्म द प्रॉमिस मेड और डिस्चार्ज द लायबिलिटी इनकर्ड। इंडेमनिटी में दो पार्टी होती है, इंडेमनिफायर एंड इंडेमनिटी होल्डर। इस वाले गारंटी में तीन पार्टी होती है, प्रिंसिपल होल्डर, प्रिंसिपल डेटर, श्योरिटी एंड क्रेडिटर। नंबर ऑफ कॉन्ट्रैक्ट्स ओनली वन कॉन्ट्रैक्ट, वहां पे तीन कॉन्ट्रैक्ट होते हैं। लायबिलिटी, द लायबिलिटी ऑफ इंडेमनिफायर इज indemnifier is primary and independent. The liability of surety is collateral or secondary. Primary liability is that of principal debtor. Nature of liability, the promise to the indemnified to save the person indemnified from a contingent risk. हो गया। Now distinguish between general line and particular, general lien and particular lien. Now, general lien. It is a right to retain all the goods of any property until all the claims of holder are satisfied. This is a right to retain the property of another for a general balance of accounts. Particular line, it is a right to retain those goods in respect of which Bailey have rendered some service involving the exercise of labor or skill. मतलब कुछ पर्टिकुलर पार्ट के लिए अगर है तो वो पर्टिकुलर लाइन है। पर्सन टेंडेड रिस्क ऑफ जनरल लाइन कैन बी एक्सरसाइज बाय बैंकर्स, फैक्टर, लॉ फिंगर्स, अटर्नीज ऑफ हाई कोर्ट एंड पॉलिसी ब्रोकर्स। राइट ऑफ पर्टिकुलर line can be exercised by any Bailey who has rendered some services by exercise of a skill and labor in respect of the goods billed. Condition: Bailey is unpaid and Bailey need not have worked upon the goods billed, and Bailey has worked upon the goods and remuneration remains unpaid. मतलब पर्टिकुलर लाइन और जनरल लाइन क्या है? जनरल लाइन मतलब किसी ने दे दिया, बेली इज अनपेड एंड बेली नीड्स नॉट हैव गुड, इट इज अ राइट टू रिटेन all the goods or any property of another until all the claims of holders are satisfied. This is a right to retain the property of another for a general balance of accounts. Right of general line can be exercised by bankers, factor, workingers, attorneys or high court and policy brokers. मतलब ये क्या है? जनरल लाइन क्या है कि बैंक अगर आपकी प्रॉपर्टी ले लेती है तो वो जनरल लाइन है कि आप अगर उसके ऊपर बेली अनपेड है, मतलब बेली अनपेड है जिसको अपन ने गुड्स बिलमेंट पे दिए है, वो अनपेड है और अपन को पेमेंट करना बाकी है। तो सो बेली इज अनपेड एंड द बेली नीड नॉट हैव वर्कड अपॉन द गुड्स। मतलब उसको ऐसा कुछ नहीं है कि उस पर काम करके फिर रिटर्न करना है, बट एज अ सिक्योरिटी उसने लेके रखा है, वो जनरल लाइन है। इट इज राइट टू रिटर्न द गुड्स इन रिस्पेक्ट ऑफ विच बेली हैव रेंडर्ड सम सर्विस फ्रॉम इन्वॉल्विंग द एक्सरसाइज ऑफ लेबर और स्किल। तो ये क्या पर्टिकुलर लाइन क्या है कि अगर अब अपन गैरेज वाले के पास जाते हैं और मैकेनिक को अपन गाड़ी दे के आ जाते हैं तो वो एक पर्टिकुलर लाइन है। सो राइट ऑफ पर्टिकुलर लाइन कैन बी एक्सरसाइज बाय एनी बेली हु हैज रेंडर्ड सम सर्विस by exercise of his skill and labor in respect of the goods billed. Bailey has worked upon the goods and remuneration remains unpaid. मतलब जब तक तू पेमेंट नहीं करेगा तब तक गुड्स मेरे पास ही रहेगा, मैंने सर्विसिंग कर दी है इसलिए। Now, temporary and perpetual injunction. Injunction. A temporary injunction is a court order prohibiting an action by party to a lawsuit until there has been a trial or other court action. Yeah, perpetual injunction. A perpetual injunction is a type of order issued by a court after a full trial on the merits of the case has been conducted. Then nature. अगर नेचर की बात करें तो नेचर, टेम्पररी इंजंक्शन इज प्रोविजनल इन नेचर, परपेचुअल इंजंक्शन इज परमानेंट इन नेचर एज कंक्लूड्स और डिटरमाइंस राइट्स अपॉन द मेरिट्स ऑफ द एज इट डज नॉट एंड कंक्लूड। फिर गवर्निंग स्टैट्यूट सीपीसी 1908, परपेचुअल इंजंक्शन स्पेसिफिक रिलीफ एक्ट 1963 में आता है। फिर स्टेज ऑफ ग्रांटिंग, इट इज ग्रांटेड before plaintiff establishes his case at the trial and continues up to a specified time. Perpetual injunction can be granted after hearing the defendant and upon the merits of the suit. Replacement temporary injunction may be replaced by perpetual injunction on merits of the case. Perpetual injunction cannot be replaced by temporary injunction. Perpetual injunction मतलब तुम अब इस प्रॉपर्टी पे कुछ हक नहीं जमा सकते. So a temporary injunction is a court order prohibiting an action by a party to a lawsuit until there has been a trial or other court action. मतलब अगर जब तक ये नहीं होता तब तक तुम नहीं कर सकते. अगर जब तक कोर्ट का रिजल्ट नहीं आ जाता तब तक तुम नहीं कर सकते. तो वो टेम्पररी इंजंक्शन है. परपेचुअल कि कोर्ट का रिजल्ट आ गया उसके बाद तुम कुछ नहीं कर सकते, उसके बाद तुम्हें प्रोहिबिट कर दिया है उस एक्टिविटी को करने के लिए, तो वो परपेचुअल इंजंक्शन होता है. फिर डिस्टिंग्विश बिटवीन रेमेडीज ऑफ स्पेसिफिक परफॉर्मेंस एंड रेमेडीज फॉर इंजंक्शन. Sometimes monetary compensation may not be adequate remedy. In that case, the aggrieved may pray to the court and may get an order against other party to fulfill obligation it has undertaken. This is known as specific relief. Orders of specific performance are issued to do specifically what party has agreed to do. Specific performance are issued for performance of contracts. Remedies for injunction where a party is in breach of a negative term of a contract, तब अपन injunction लगाया. That is where he is doing something which he has promised not to do. The court may by issuing order restrain him from doing what he promised not to do. So such an order of the court is known as injunction. Orders of injunction are issued from prohibiting a person from doing what he has promised not to do. Injunctions can be issued for the contracts as well as for torts. तो स्पेसिफिक परफॉर्मेंस सिर्फ कॉन्ट्रैक्ट्स पे, अपना ये वाला जो है रेमेडीज फॉर इंजंक्शन वो कॉन्ट्रैक्ट्स एज वेल एज टॉर्ट्स के लिए, दोनों के लिए अपन इस्तेमाल कर सकते हैं. फिर डिस्टिंग्विश बिटवीन रेक्टिफिकेशन ऑफ कॉन्ट्रैक्ट, रेक्टिफिकेशन ऑफ इंस्ट्रूमेंट एंड कैंसलेशन ऑफ इंस्ट्रूमेंट. When instrument may be rectified where a contract reduced into writing in pursuance of a previous agreement but fails to express the real intention of the parties, the court will rectify the instrument in accordance with their true intention. The court allows rectifying the instrument if the following conditions are satisfied. There must a capable agreement and it must be in writing. There must be a clear evidence of mutual mistake or a fraud. It does not show the real intention of the parties. However, this section does not apply to the Articles of Association to which the Companies Act 2013 applies. It shall be noted that no relief for the rectification of instrument shall be granted to any party under this section unless it has been specifically claimed. The only limitation placed on the court discretion is that the rectification can be done without prejudice to the right acquired by the third person in good faith and for value. When cancellation may be ordered. A written document which is void or voidable against a person may cause him, in some cases, a serious injury if it has left outstanding. In such a case, if he has any such apprehension, he may file a suit to have the document adjured void or voidable. Conditions for relief. The instrument sought to be cancelled is void or voidable against the plaintiff. He has reasonable apprehension of serious injury from the instrument if it is left outstanding. That the apprehended injury is serious and in view of the circumstances of the case, the court considers it reasonable and necessary to cancel the contract. Distinguish between future goods and the contingent goods. Goods which are not possessed by the seller at the time of contract of sale, but will be manufactured, produced, or acquired by the seller after the contract of sale are known as future goods. When contingent goods, when acquisition of the goods depends upon happening or non-happening of future certain events, that goods are known as contingent goods. Uncertainty, there is no uncertainty in case of future goods. There is uncertainty in case of contingent goods. Scope, future goods do not include contingent goods. Contingent goods include the future goods. Effect of the contract. In case of future goods, the contract operates as an agreement to sell the goods. In case of contingent goods, the contract operates as contract for sale of goods. X makes a contract with Y, a farmer, to purchase all wheat produced in his during the season. At the time of making contract, Y was not in possession of wheat, so it is a future goods. X, a fisherman, agrees to sell fish to Y that may be caught in sea. Getting fish in sea is uncertain future event. Hence, fish in this case is a contingent goods. Sale and agreement to sell. Sale. If the property in the goods is immediately transferred from the seller to the buyer, it is called sale. अगर property immediately transfer हो रही है तो वो sale है. If property in the goods is to make the place at a future time or subject to fulfillment of some condition, it is known as agreement to sell. It is executed contract. It is an executory contract. Type of goods. In sale, goods are specific and uncertain. In agreement to sell, goods are future and contingent. It is sale creates rights in rem, that is right against the whole world. Agreement to sell creates a right in personal, that is right against a specific person. In sale, property and goods transfer to buyer, so buyer bears the risk of loss. Even if in sale, property and goods transfer to buyer, so buyer bears the risk. मतलब सेल में प्रॉपर्टी का रिस्क फटाफट उसी टाइम पे इमीडिएटली ट्रांसफर हो जाता है, तो इसलिए उसका जो रिस्क है वो बायर ही बेयर करेगा. इन एग्रीमेंट टू सेल, प्रॉपर्टी इन द गुड्स इज टू टेक प्लेस एट अ फ्यूचर टाइम और सब्जेक्ट टू फुलफिलमेंट ऑफ सम कंडीशन. So seller continues सो सेलर कंटिन्यूज टू बेयर द रिस्क। मतलब इसमें क्या होता है कि जब फ्यूचर में अग्रीमेंट टू सेल होता है तो फ्यूचर में जब बेचने को बोलेंगे तो फ्यूचर में बेचना है, तो इसलिए आज के लिए जो आज के दिन के लिए जो रिस्क है वो सेलर के पास ही रहेगा। फिर एग्जांपल, एक्स अग्रीज टू सेल 100 बैग्स फॉर wheat to Y, which are ready for delivery. This is contract of sale. X, a farmer makes a contract with Y to sell all wheat produced in his field during the season. This is an agreement to sell. A sale is liable to sales tax. An agreement to sell is not liable to sales tax. Proper एकदम कुछ नहीं है. Rights of buyer if sale. In sale, if buyer has paid the price, he can sue the seller for non-delivery of the goods. In agreement to sell, if buyer has paid the price, he cannot sue the seller for non-delivery of goods. He can sue for the damages only. Breach of contract by the buyer. In sale, if there is a breach of contract by the buyer, seller can sue for the price of goods, resell the goods, exercise the right of lien, exercise right of stoppage in transit in agreement to sale. If there are breach of contract by the buyer, seller can sue only for the damages and not for the price. Breach contract by the seller in sale. If there is a breach of file a sue for damages, file a sue for suit for the delivery of goods in agreement to sell. If there is a breach of contract by the seller, buyer can sue only for the damages. Insolvency of buyer. If in a sale, if buyer becomes insolvent, seller must give the goods to the official assigner or receiver. Seller can claim only rateable dividend for the price in agreement to sell. If the buyer becomes insolvent, seller is not under obligation to give the rights to the give the goods to the official assignee or the receiver. What? Insolvency in a sale, if the seller becomes insolvent, buyer can claim the goods from the official assignee or receiver. In agreement to sell, if seller becomes insolvent, buyer can claim only a rateable dividend for price from the official assignee और receiver. फटाफट इमीडिएटली ट्रांसफर फ्यूचर टाइम पे होता है, एग्जीक्यूटेड कॉन्ट्रैक्ट एग्जीक्यूटरी, फिर स्पेसिफिक एंड सर्टेन गुड फ्यूचर एंड कंटीजेंट गुड, राइट इन ड्राफ्ट, राइट इन पर्सोनम, फिर बायर बेयर्स द रिस्क, सेलर सेलर बेयर्स द रिस्क, फिर एग्जांपल ले लेना, सेल्स टैक्स सेल पे ही लगता है, एग्रीमेंट टू सेल पे सेल्स टैक्स नहीं लगेगा, फिर राइट्स ऑफ बायर has paid price non-delivery of goods पे he can sue the seller for the non-delivery in agreement. Buyer has paid price, he cannot sue for the, फिर breach of the contract by buyer, breach contract by seller, फिर insolvency of buyer, इंश्योरेंस अगर बायर की हो गई तो उसको ऑफिशियल असाइनी को दे देना, इंश्योरेंस ऑफ सेलर हो गई तो ऑफिशियल कैन क्लेम द गुड्स फ्रॉम द ऑफिशियल असाइनी, तो वो एकदम सिंपल रूल है। फिर डिस्टिंग्विश बिटवीन सेल एंड कॉन्ट्रैक्ट, कॉन्ट्रैक्ट फॉर वर्क एंड लेबर। पहले, if the property in the goods is immediately transferred from the seller to the buyer, it is called the sale. It is a contract for executing certain work and involves exercise of skill. In sale, there is a delivery and transfer of ownership of goods. Contract for work and labor involves transfer of some material and exercise of skill and in labor belonging to the other person. Excuse his old car to buy for repair and also request to replace some old parts. This is contract for work and labor. सेल का तो अपन को पता है। सेल एंड हायर परचेज, द प्रॉपर्टी इन द गुड्स, ये साइड का आप नहीं बोलेंगे। हायर परचेज है कॉन्ट्रैक्ट इन विच गुड्स आर डिलीवर्ड एंड द price is allowed to be paid in installments, is allowed to be paid in the installments, is allowed to be paid on installments on the condition that the property will be passed only on the payments of all the installments। फिर ये जो अपना सेल है वो सोलह पे आता है, ये हायर परचेज एक्ट पे आता है। फिर पोजीशन इन सेल, buyer becomes owner of the goods. Hire purchase is only a daily until pays all the installments. Buyer cannot terminate the contract. Hire purchase has an option to terminate the contract. Resale, resale buyer or hire purchase buyer, if buyer had not paid the full price and sells the goods to the third party for a value, who are acting in good faith will get a good title. If hire purchase had not paid all the installments and sell goods to the third party, then the third party would not get a good title since the hirer himself had not titled the goods। मतलब अगर हायर परचेजर अपने पूरे इंस्टॉलमेंट्स पे नहीं किया और उसके पहले ही उसने बेच दिया तो फिर उसके पास ही टाइटल गुड नहीं था, तो वो आगे गुड टाइटल फॉरवर्ड नहीं कर सकेगा। फिर डिफॉल्ट बाय बायर और हायर परचेज, बायर मेक्स डिफॉल्ट, सेलर इफ बायर मेक्स डिफॉल्ट, सेलर कैन sue for the price and exercise right of lien. If hire purchaser makes default, the seller can take a repossession of the goods. Now, सेल एंड बिलमेंट में सेल्स का साइड का बहुत बार पढ़ लिया। फिर बिलमेंट इज डिलीवर ऑफ गुड्स बाय वन पर्सन टू अनदर फॉर सम पर्पस upon a contract that they shall, when the purpose is accomplished, be returned or otherwise disposed of according to the instructions of the person delivering them. A contract of bailment may be entered without consideration. This happens in gratuitous bailment. In contract, there is a consideration. Return of goods in contract. In contract of sale, buyer is not required to return the goods. In contract of bailment, the bailee has to return the goods. Has to return the goods after the purpose is over. In contract of goods ownership, is with bailor as only possession is transferred to bailee and hence risk of goods is with bailor. Risk follows ownership and hence, in case of contract of sale, risk of goods with the buyer. Contract of sale is governed SOGA and this is done by Indian Contract Act 1872 bailment. फिर डिस्टिंग्विश बिटवीन कंडीशन एंड द वारंटी. A condition is a stipulation essential to the main purpose. It is a collateral to the warranty is a collateral to the main purpose. Effect of breach. Breach of condition gives rise to the right to claim damages as well as to treat the contract as repudiated. Breach of which gives right to a claim for damages, but not to reject, but not to a right to reject the goods and treat the contract as repudiated. Depth condition goes directly to the root of the contract. Warranty does not go directly to the root of the contract. Interchangeability. Breach of condition may be treated as a breach of warranty. Breach of condition can be treated as breach of warranty. Breach of warranty cannot be treated as breach of condition. X places an order to Y for some lorries to be used for heavy traffic in a hilly area. The lorries supplied were unfit. There is a breach of condition and Y can repudiate the contract. X sells cars to Y and also promises to replace or repair some part. If any defect occurs within the 1 year, stipulation to replace or repair some part is a warranty. Warranty मतलब collateral part. Collateral the main purpose of the contract. वो collateral है. Warranty condition main essential to the main purpose of the contract. Partnership and HUF. Partnership is a relationship between persons who have agreed to share the profits of a business carried on by all or any of them. For the all, HUF can be defined as a family that consists of a common ancestor and all his male descendants and their wives and unmarried daughters. Creation. Partnership is created by an agreement. Partnership is created by an agreement. Right in joint family is created by status, that is by birth of a male child in the family. Maximum number of members. The partnership with the objects of acquisition for gains cannot be formed beyond 50 members of partners. No restriction as to the maximum number of members. Registration of partnership is not compulsory, but the partnership act had made it indirectly essential to enjoy certain benefits. Registration is not required. Management. All partners are equally entitled to a right of management of the business. Right of management of joint family business generally vests in Karta, the governing male member of the family. Authority to bind. Every partner binds the firm. Karta has the authority to contract for the family businesses. Liability for all the partners is unlimited. Only the liability of Karta is unlimited. Co-partners is liability only to their share. Rights to verify accounts. A partner can bring a suit against the firm for accounts provided he also seeks the dissolution of the firm. On separation of joint family, a member is not entitled to ask for accounts of the family business governed by Partnership Act 1932. Hindu law. Minor cannot become a partner but can be admitted to the benefits of the partnership with consent of all the partners. Minor becomes a member by his birth. Death of a partner leads to dissolution of partnership. Death of member in HUF does not lead to the dissolution. ठीक है. मैं HUF और partnership का डिफरेंस आता है. तो distinguish between partnership and co-ownership. Partnership is the relation between persons who have agreed to share. When two or more persons hold a property and agrees to share profit, their relationship is called co-ownership or joint ownership. Agreement must be to carry on the business. There is no necessary there is no necessary for any separate business. Number of members of partnership with objects 50 members. There is no limit on the number of persons being co-persons. Partnership arises from a contract or the agreement. It may arise by contract and also by status. Example, A and B inherit a house from their father. Transfer of interest. Partner cannot transfer his interest or share without consent of all other partners. Owner may transfer his interest or share to a third partner without the consent of other co-owners. Every partner is principal as well as an agent of other partners. A co-owner is not the agent of the co-owners. Partnership involves sharing of profit and losses. It does not always involve sharing of profit or losses because it may exist without any business. Lien. A partner has a lien on the form of the property. A co-owner has no lien on the property. तो एक बार फिर से फटाफट. Partnership is a relation between persons who have agreed to share the profits of the business and carried on by all or any of them. When two or more persons hold a property and agrees to share a profit, their relationship is called co-ownership or joint ownership. No necessary of separate business. यहाँ पे to carry on business होना चाहिए. फिर 50 मेंबर्स होते हैं पार्टनरशिप में, यहाँ पे कोई लिमिट नहीं है। क्रिएशन, पार्टनरशिप अराइजेस फ्रॉम अ कॉन्ट्रैक्ट, यहाँ पे स्टेटस से क्रिएट हो सकती है। ट्रांसफर ऑफ इंटरेस्ट विदाउट कंसेंट ऑफ ऑल द अदर पार्टनर्स, इंटरेस्ट without consent of other co-owners. Every partner is principal as well as an agent of other partners. Co-owner is not the agent of other co-owners. Involved sharing of profits and losses may exist without any business. A partner has a line on the firm property. A owner has no line on the property. Distinguish between sale and bailment of ऊपर पढ़ लिया तो ठीक है ये। Distinguish between partnership, dissolution of partnership and dissolution of firm. Dissolution of partnership, any change in the relationship between any change in the relations of partner is called dissolution of relations of the partner is called dissolution of partnership. This may happen due to admission, retirement, or death of the partner. Dissolution of partnership between all the partners of a firm is called the dissolution of firm. Dissolution of partnership between all the partners, मतलब सबने 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 बोल दिया कि भाई आप डिसोल्यूशन करना है तो वो डिसोल्यूशन ऑफ फर्म होगी। बिजनेस ऑफ द फर्म कंटिन्यूज एज बिफोर, बिजनेस ऑफ द फर्म कम्स टू एन एंड। रिलेशन ऑफ पार्टनर कंटिन्यूज to exist but in a changed form. Relation of partners comes to an end. फिर अकाउंट इन केस ऑफ डिसोल्यूशन ऑफ पार्टनरशिप, रिवैल्यूएशन अकाउंट, यहाँ पे रियलाइजेशन, बुक ऑफ अकाउंट्स आर क्लोज, बुक्स ऑफ अकाउंट्स आर नॉट क्लोज। डिसोल्यूशन ऑफ पार्टनरशिप में, डिसोल्यूशन ऑफ पार्टनरशिप क्या है? एनी चेंज इन द रिलेशनशिप ऑफ पार्टनर इज कॉल्ड डिसोल्यूशन ऑफ पार्टनरशिप। दिस में बी एडमिशन, रिटायरमेंट और डेथ ऑफ एनी ऑफ द पार्टनर। डिसोल्यूशन ऑफ पार्टनरशिप बिटवीन ऑल द पार्टनर्स ऑफ फर्म इज कॉल्ड द डिसोल्यूशन ऑफ द फर्म। Business of the firm continues as before. Business of the firm comes to an end. Relation of partner continues to exist but in a change from relation of partner comes to an end. Account revaluation account बनता है, यहाँ पे realization account बनता है, और books of accounts are closed and books of accounts are not closed and books of accounts are closed over in dissolution of firm. Now bills of exchange and promissory note. A bill of exchange is an instrument in writing containing a bill of exchange is an instrument in writing containing an unconditional order signed by the maker directing a certain person to pay a certain sum of money only to or to the order of a certain person or to the bearer of the instrument. Bill of exchange both are promissory note is an instrument in writing, not being a bank note, containing an unconditional अंडरटेकिंग। यहाँ पे सिर्फ डिफरेंस एक ही है, अंडरटेकिंग होता है, यहाँ पे ऑर्डर होता है। बिल ऑफ एक्सचेंज के करना ही पड़ेगा, प्रॉमिसरी नोट मतलब अंडरटेकिंग होता है, साइन बाय द मेकर टू पे अ सर्टेन सम ऑफ मनी ओनली टू और टू द ऑर्डर ऑफ अ सर्टेन पर्सन or to the bearer of the instrument. Liability of the maker. The liability of the maker or drawer is secondary and conditional. The liability of the maker or drawer is primary and absolute. Order of promise, it contains an unconditional order. यहाँ पे unconditional promise होता है. It is drawn by the creditor. It is drawn by the debtor. Acceptance. Acceptance by the drawee is a must. Acceptance is not required. Draw. मतलब promissory note में acceptance जरूरी नहीं है, but बिल ऑफ एक्सचेंज में एक्सेप्टेंस करना पड़ेगा, तभी वो बिल ऑफ एक्सचेंज वैलिड माना जाएगा। पे drawer of the bill may be the payee also. The maker of the note cannot be the payee. Parties, there are three parties: drawer, drawee, and payee. There are two parties: maker and the payee. Now, distinguish between electronic and truncated. The electronic check is never in the paper form. The truncated check is initially a regular check on paper. It is submitted at bank as usual for clearance. Original writing. The original writing itself is in electronic form. The truncated check is duly written and signed on paper. It is subsequently converted into electronic form. Signature. Original signature is digital signature. Original signature is in ink. मतलब जो स्कैन करके वो भेजते हैं वो ट्रंकेटेड, और जो डायरेक्ट ऑनलाइन ही पेमेंट करता है वो इलेक्ट्रॉनिक चेक होगा। फिर holder and holder in due course. The holder of negotiable instrument means any person entitled in his own name to the possession thereof and to receive or recover the amount due thereon from the parties thereto. Holder in due course means any person who for consideration becomes a possessor of a negotiable instrument before the amount mentioned in it become payable and without having sufficient cause to believe that any defect existed in the title of the person from whom he derived his title. A holder may or may not be the holder in due course. A holder in due course is obviously a holder. पहले holder होगा फिर holder in due course बनेगा ना। Title. Holder cannot acquire a good title if the title of the prior party was defective. मतलब अगर होल्डर के पास अगर बिल ऑफ एक्सचेंज है और अगर प्रायर पार्टी का टाइटल डिफेक्टिव था तो उसके पास बेटर टाइटल नहीं आ सकता। फिर होल्डर इन ड्यू कोर्स अक्वायर्स अ गुड टाइटल इवन इफ द टाइटल ऑफ प्रायर पार्टी वाज डिफेक्टिव। मोड mere holder need not necessarily be for consideration. Example here of deceased holder becoming entitled to the bill is holder, not holder in due course. Similarly, assignee of bill is holder but not the holder in due course. A person can become a holder in due course only after paying or transferring of sum consideration. Acquisition of instrument. Holder may acquire instrument even after maturity, but in such case, he will not be holder in the due course. Holder in the due course must possess or acquire before the maturity. मतलब जब maturity होगी उसके पहले ही holder in due course के पास बिल होना चाहिए. Enforcement. A holder cannot enforce instrument which was previously obtained by unlawful means. मतलब अगर पहले का टाइटल डिफेक्टिव था और पहले का अनलॉफुल था तो वो आगे वो उसको एनफोर्स नहीं कर सकता. बट अ होल्डर इन ड्यू कोर्स कैन एनफोर्स इंस्ट्रूमेंट इवन इफ इट वाज प्रीवियसली ऑब्टेन्ड बाय unlawful means or unlawful consideration. Fictitious bill. Holder who is not the holder in due course cannot claim payment on the fictitious bill. A holder in due course can claim the payment on fictitious bill because we as we talked that holder in due course के पहले जो भी कांड हुआ है वो मिट जाता है अगर वो होल्डर इन ड्यू कोर्स है. फ्रॉड एंड कोहेजन. Instrument initially issued or obtained under fraud, coercion without consideration cannot be enforced by the holder. He is not the holder in due course. A holder in due course can enforce instrument initially issued or obtained under fraud, coercion, or without the consideration. Distinguish between inland bills and foreign bills. Inland bills, following types of bills are called inland bills. The land drawn in India, payable in India. The bills drawn in India on resident person, whether payable in India or outside India. The bills drawn in India upon a person resident outside India but payable in India are known as inland bills. Foreign bills, an instrument which is not an inland instrument is deemed to be a foreign instrument. Where copies, inland bills are drawn in a single copy, foreign bills are drawn in triplicate copies. Noting and protesting in case of dishonor of inland bills. Noting is required in case of dishonor of foreign bills. Protesting is required. दोनों में in case of noting is required and in case of dishonor of foreign bills protesting is required. दोनों चीज अलग है. नोटिंग और यहाँ पे प्रोटेस्टिंग रिक्वायर्ड है. फिर check and bill of exchange. A check is a bill of exchange drawn on a specified banker and not expressed to be payable otherwise than on demand. A bill of exchange as an instrument is writing containing an unconditional order signed by the maker directing a certain person to pay a certain sum of money only to order the order of a certain person. वो हो गया drawn. It must be drawn on a specified banker. मतलब ये specified banker पे ही draw होता है. Check. Bill of exchange it may or may not be addressed to the banker. फिर payable to the bearer. It can be made payable to the bearer. It cannot be made payable to the bearer on demand. मतलब जो ब्लैंक चेक होता है वो चेक में हो सकता है बट बिल ऑफ एक्सचेंज ब्लैंक होता है तो उसका कोई मतलब नहीं होता. फिर ऑन डिमांड. इट मस्ट बी पेबल ऑन डिमांड. इट कैन नॉट बी मेड पेबल ऑन डिमांड. मैच्योरिटी वाला ही होता है. देयर इज नो ग्रेस पीरियड. 3 days पीरियड ऑफ ग्रेस इज अवेलेबल. चेक कैन बी क्रॉस. इट कैन नॉट बी क्रॉस्ड. प्रेजेंटेशन फॉर एक्सेप्टेंस इज नेवर रिक्वायर्ड. प्रेजेंटेशन फॉर एक्सेप्टेंस इज रिक्वायर्ड मतलब उसको जाके प्रेजेंट करना पड़ेगा. स्टैंपिंग. इट इज नॉट रिक्वायर्ड टू बी स्टैम्प. इट इज रिक्वायर्ड टू बी स्टैम्प. अपन को बिल ऑफ एक्सचेंज पे स्टैम्प करवाना पड़ता है. चेक पे थोड़ी करवाते हैं. Due date. There is no due date for presentation of check. It is required to be presented for payment on due date. Bankers have to stop payment of check if drawer is dead or insolvent. Dead or insolvent हो गया and bank has notice of the same. There is no provision to stop payment if party is dead or insolvent or becomes insolvent after the signature. Stop payment नहीं करवा सकते bill of exchange में. फिर notice of dishonor. Notice of dishonor is not required unless holder. Notice of dishonor is not required unless holder intends to take criminal action against under section 138. Notice of dishonor is usually required. Noting and protesting. It cannot be noted and protested. It can be noted and protested. Criminal liability. Criminal liability gets attracted if check is dishonored. There is no criminal liability for dishonor of bill of exchange. फिर से एक बार फटाफट कर देते हैं. Drawn on. It may be drawn on the specified banker. It may or may not be on banker. It can be payable to the bearer. It cannot be made payable to the bearer. It must be made payable on demand. It cannot be made payable on demand. No grace period. 3 days grace period is available. Check can be crossed. It cannot be crossed. Presentation for acceptance is never required. Is required. Stamping is required to be stamped. It is not required to be stamped. It is required to be stamped. Due date. There is no due date for presentation of check. It is required to be presented for payment on due date. Stop payment. Bankers have to stop payment if dead or insolvent and bank has notice of the same. There is no provision to stop payment if party to instrument is dead or insolvent or becomes insolvent after the signature. Notice of dishonor. Notice of dishonor is not required unless holder intends to take criminal action against under section 138. Notice of dishonor is usually required. Noting and protesting. It cannot be noted and protested. It can be noted and protested. Criminal liability arises. No criminal liability arises for dishonor of bill of exchange. Now, accommodation and trade bill. A bill which is drawn for mutual finance is called an accommodation bill. Bill drawn and accepted for a genuine trade transaction is termed as trade bill. इट इज ड्रॉन विदाउट एनी कंसिडरेशन, मतलब अकोमोडेशन बिल मतलब सिर्फ फाइनेंस का अदला बदली करने के लिए अगर हुआ तो फिर उसको अकोमोडेशन बिल बोलते हैं, बट जेन्यून ट्रेड ट्रांजेक्शन वो ट्रेड बिल होगा, इट इज ड्रॉन फॉर अ कंसिडरेशन. The bill is for mutual financial help. So the bill is evidence of the debt, acknowledgement of debt. These bills are not acknowledged as debts. These bills are acknowledged as debts. Discounting with the banks. The bills are always discounted with these bills may or may not be discounted with the banks. Loss by way of discounting. The loss by way of discounting the bill has to be shared by drawer and drawee in the ratio in which they share the proceeds. The loss by way of discounting the bill has to be borne by the drawer. Legal action cannot be taken up by drawer in case of dishonor of the bill. Where legal action can be taken in case of dishonor. Legal action cannot be taken up in case of dishonor of a bill, can be taken up by drawer in case of dishonor of the bill. फिर negotiation and assignment, लास्ट के दो ही बाकी है, acceptance and दो ही बाकी, negotiation and assignment. Negotiation means transfer of a negotiable instrument to another person so that such other person is entitled to the position of the instrument and receive amount of the instrument on due date. Negotiation मतलब किसी को दे देना. Assignment means transfer of interest to the another. अपने को दूसरे को ही दे दिया. फिर title holder in due course after negotiation can get better title than the transferor. Assignee cannot get better title than the assigner. Notice of endorsement. Notice of endorsement is not required in is not necessary in negotiation. Notice of assignment is required to be given to the debtor in case of assignment of debt. Form negotiation of bearer instrument can be simply by delivery. Assignment must be in writing as per section 130 of the TOPA. Consideration is presumed in negotiation. Consideration is not presumed in assignment. Further endorsement and negotiation. A negotiable instrument can be further endorsed without permission or even without knowledge of transferor. An assignee can further assign only if such right is specifically conferred on him by the assigned assignment date. Stamp duty. Once original instrument is stamped, further negotiation does not require payment for stamp duty. Each assignment will require a fresh stamp duty. And the last but not the least, acceptance for honor and the payment for the honor. If a bill is dishonored by non-acceptance, another person who was party to the bill can accept the same for honor of the drawer after bill is noted or protested, which is known as acceptance for honor. If a bill is dishonored by non-acceptance, another person who was not the party to the bill can accept the same for honor of drawer after bill is noted or protested, which is known as acceptance for honor. When payment is made by any person for the honor of any party liable to pay is known as payment for honor. मतलब जब payment करता है वो payment for honor होता है. When acceptance for honor is given before the bill is due, payment for honor is only after bill is due. Consent of holder of bill is necessary in case of acceptance for honor. Consent of holder of bill is not necessary in case of acceptance for honor. Rights. Acceptor for honor is entitled to get compensation for all loss and damages sustained by him. Person paying the bill gets all the rights of holder of the bill. After payment, he can recover interest and expenses from party in whose honor he made the payment. And that's it. That's all the differences we have covered in 1.5 hours.